to appear for the first accused, together with the following: Professor George Okoye.
Present, Your Honor.
We have Honorable Eugene Omalo.
Present, Your Honor.
A minute. Help me with the spellings of what they acquired. Sometimes it's confusing. It is
Tutasonga hapa na watu wanapita.
W-A-J-A-C-O-Y-A, right?
Utaona wamejificha.
That is Honorable Eugene
Omalo. We have Honorable Senator Manzo. We have Ndego Joe. We have Albert Siliu Mirandi.
I'm present, Your Honor.
the last name?
Mugambi.
Omuragi.
Yes.
We have Simon Nguru. I'm present. We have Willie Sekino. We have Asha Bashir. Zan Alakonya. Edgar Sieba. I'm sure Cuban is great. Then Cuban Mungai. I should also wish to have it placed on record. The Senior Counsel, Honorable Kalonzo Musyoka, will also be joining. And Senior Counsel, Honorable Mada Karua. We wish also to add Ken Ichesa.
I'm present, Your Honor.
Walubengo Waningilo.
Present, Your Honor.
So the last name?
Walubengo Waningilo.
Spell for me kindly.
WANINGILO. And finally, Mr. Obuli.
That is Mr.
Obuli.
Appearance of the second accused.
Yes, Your Honor, the matter is coming up for plea. We are ready for plea. We shall find our sources. And even sir.
Atajipanga bwana.
Your Honor, we just been served with charge sheet now. We just informed.
Mr. Ndero, ready? Mr. Ndero. Mr. Ndero, you ready for plea?
We are reaching.
You have issued, but you ready? Lombardi, you have not commented about the second accused.
One comment raised that we will pray for someone for the second accusation, but we'll deal with that later.
Proceed.
Natembeya, which language do you understand? English or Swahili? Which language do you prefer?
The mic is not working, right?
Count number one, against accused number one. Conflict of interest contrary to section 42(3) as read with section 48 of the Anti-Corruption and Economic Crime Act of 2003. Particulars of the offense being George Natembeya between 1st January 2023 and 30th April 2025 within the Republic of Kenya, being an agent of a public body to which the governor of the county government of Trans-Nzoia, you knowingly acquired an indirectly pecuniary interest in the sums of Kenya shillings 1,127,900 from Mercy Chelagat, the director of Lima Agro Science Limited and the proprietor of Myra Stores, which traded with the county government of Trans-Nzoia. Is it true or not true?
Not true.
Count number two, conflict of interest contrary to section 42(3) as read in section 48 of the Anti-Corruption and Economic Crime Act of 2003. Particulars of the offense: George Natembeya between 1st January 2023 and 30th April 2025 within the Republic of Kenya, being an agent of a public body to the governor of county government of Trans-Nzoia, you knowingly acquired an indirectly pecuniary interest of the sum of Kenya shillings 2,124,668 from Emmanuel Wafula Masungo, the beneficial owner of Easterly Wheels Limited, which traded with the county government of Trans Nzoia. Is it true or not true? Count number 4. Unlawful acquisition of public property contrary to section 45(1)(a) as read in section 48 of the Anti-Corruption and Economic Crimes Act of 2003, particulars being George Natembeya between 1st January 2025 and 30th April 2025 within the Republic of Kenya, being the governor of Trans Nzoia County Government, you unlawfully acquired public property to wit Kenya shillings 3,252,568, being part of the payment made by public government of Trans Nzoia to Lima Agro Science Limited, Maira Stores and Easterly Wheels Limited in conflict of your public interest. Is it true or not true?
Jerry?
Now, Your Honor, these are the simple charges in the case of we are utterly shocked to see that we've been served in an affidavit by the prosecution to purport to oppose bail. The directions you need to give us is whether you wish the prosecution to go fast, you will respond to it, because you would have expected the narrative that the accused person should have been released on bail, actually free bail, so to speak. But we have an affidavit that is served on us now when we charge it.
Even if I may, my name is Awiti. We have instructions to oppose pay, instructions from our client, the Director of Prosecutions. And as regards Mr. Nyeru, Mr. Nyeru's request for directions, we believe that because we oppose bail, and bail being ordinarily a right, then it has to go first in an application to oppose bail. They'll have a chance to respond to our application. That's a great way I can go upon our arguments. My learned senior, Mr. Akula, will take the court through the affidavit, the factual matrix. Allow me to take the court through the legal matrix. Now, I'll start by indicating that the law on bail is almost settled. Sorry, Your Honor. All right. My apologies. My apologies. I come from the lakeside. I speak
I know.
Your Honor, our application in Thank you, Your Honor. You know, like I was indicating, the law on bail and bond in Kenya is settled, or almost settled, if not settled. And our arguments are founded on Article 59(1)(h) of the Constitution. Article 50, there, sections
159.
49(1)(h)
49(1)(h)
of the Constitution. 50 thereof. Section 123 and 123 capital A of the Criminal Procedure Code. And of course, Section 8 of the Magistrates Court Act, which gives this court the jurisdiction to entertain this matter this morning. You know, it is the import of Article 49(1)(h) that bail is a constitutional right, and that every arrested person or an accused person has an entitlement to bail unless there are compelling reasons to deny him bail. Now, we submit to you, and we believe that at the tail end of our submissions on the prosecution side, we shall have established at least 3 compelling reasons, at least 3, there could be more, to justify this court's denial of bail for the accused person before you. And Your Honor, just to emphasize, the import of Article 59(1)(h) is that while bail is a constitutional right which should ordinarily be granted, where such compelling reasons are established, the court must deny bail. You know that you do not have a discretion. Where we establish compelling reasons, you cannot exercise any discretion. You must deny bail. And Your Honor, just on the question, so, Your Honor, unfortunately, I'm not able to read the court's pen. I'm short as well. The court could guide me when I'm able to proceed. I appreciate that.
Every sentence was.
Thank you. Yes. You know, that further on the question of discretion, the discretion that the court has on the question of bail then arises where the court has dismissed all the compelling reasons and is to set terms and conditions of bail. That therefore, Your Honor, where there are compelling reasons, as is our submission, then the court cannot grant bail, and therefore the court does not have to get to the discretion of setting terms or conditions of bail. You know, because I have had the benefit of appearing in the number of counsel for the defense in this matter, I can preempt what they are likely to tell you. That the right to bail is also, I am normally wrong, so I may be wrong to preempt them, but I promise they will say what I'm telling you.
If you can give them a chance to state what they are.
You know, I am allowed to preempt and give
The
arguments.
defense has the capacity, Your Honor, and we will not want the counsel to belabor.
just speak for the state which he
A minute,
represents.
a minute.
The accused has sufficient
A
defense.
minute. Decorum. Decorum. I repeat for the third time. Decorum. Mr. Witty, can you give directions? Give the defense time to state what they have to state. State what you have to state.
That's right.
Yes.
There is the question of the relationship between the right to bail and the presumption of innocence. It is straight law.
Pause.
Oh.
It is right law.
It is straight law that the denial of bail, where there are compelling reasons, is not a breach of the presumption of innocence. I trust the court to have a look at Chomley case. I'm not very good with spelling of the pronunciation of the word. We do not have copies of that authority, but because this court can notice there, the Chomley case is clear on the relationship between the right to bail and sorry?
At the High Court level or Court of Appeal?
The High Court. Sorry, the High Court.
High Court.
Yes. And therefore that if this court finds that there are compelling reasons, or at least one, Your Honor, because just one compelling reason is sufficient to deny bail, then that does not in any way breach the presumption of innocence. Your Honor, I will also invite you to Article 24 of the Constitution, vis-a-vis Article 25 thereof, on the limitation of rights under the Constitution. And the effect thereof is that the only rights that cannot be limited are the rights under Article 25. And that the right to liberty or any other right that may be alleged to be violated, including the right of presumption of innocence, by denial of bail, can be permissibly limited by dint of Article 24 of the Constitution. The net effect thereof is that a denial of bail where there is compelling reason or compelling reasons amounts to a permissible limitation of rights under Article 24 of the Constitution. Whereas a compelling reason has not been defined by statute in Kenya, have guidance from the Judiciary Bail and Bond Policy Guidelines. Judiciary Bail and Bond Policy Guidelines, together with 7 decisions of superior courts in the land, that is the Court of Appeal and the High Court. And Your Honor, that the list provided in the Judiciary Bail and Bond Policy Guidelines is not exhaustive. But without going to the particular facts which my learned senior Mr. Kula is following me to talk about, that list includes, as compelling reasons, the likelihood of interference with witnesses, the likelihood to interfere with ongoing investigations, and the likelihood to interfere with exhibits. You know, in concluding on the legal issues, the primary purpose of bond is to ensure that an accused person shall be present for trial. But there is the secondary corollary purpose of bond, which is to protect the integrity of the trial before you. Protection of the integrity of the trial before you. So that, Your Honor, even where it is shown that an accused person shall turn up for trial, if released on bail, we are releasing an accused person on bail will prejudice the integrity of the trial. We are releasing an accused person on bail, even when it is shown that they will attend trial. We are releasing them on bail will prejudice the trial, and therefore the integrity of the trial. This court has a reason, a compelling reason to deny them bail. A likelihood to interfere with witnesses, exhibits, or ongoing investigations is a high likelihood of interference with the integrity of a trial. That is our submission. Allow me to say the last thing on section 8, subsection 2 of the Magistrates Court Act. Section 8, subsection 2 of the Magistrates Court Act deals with the court's jurisdiction, I mean subordinate court's jurisdiction, to enforce Bill of Rights, or questions of interpretation relating to Bill of Rights. jurisdiction is limited to Article 25A and B of the Constitution. The rights under Article 25A and B of the Constitution. It is a clear statutory statement that this court's power to enforce Bill of Rights is limited to the rights under Article 25A and B and nothing more. So that, Your Honor, reference to constitutional provisions as regards Article 49 on bail can only be made in respect of 25A and B. Anything outside of that is outside your jurisdiction, and where you have no jurisdiction, you pen down on those questions of constitutional interpretation if raised. I am honored to appear before you. I thank you and invite my learned senior, Mr. Akulo.
And on your file an affidavit sworn on 19th May 2025 by Mr. Robert Swan.
So on.
19th of May 2025, this one. Yes, sir, Your Honor. Trial this morning. Yes, sir. Your Honor, it is sworn by Robert Swan. Robert Swan. And ESCC forensic examiner. There are the factual reasons or grounds to take bail are therefore from paragraph 1, paragraph 2, however. I will cluster them into
Paragraphs
three,
1
1 to paragraph 12. And however, I will cluster them into three compelling reasons. The first one, interference with witnesses. The second one, public safety. And lastly, the severity of the offense. For the first compelling reason, my Lord, Your Honor, we submit that subject to this case, there are other ongoing investigations. Which at paragraph 3 and 4 confirm that paragraph 3 and paragraph 4 of the affidavit confirm that the accused person through his agents, the accused person through his agents attacked ESCC and LPS officers in lawful exercise of their duties. Now this has been reported and is captured under annexure number R38. Italy Police Station. R38. PR38. Annexure PR38.
jurisdiction known is founded on section 106B of the Evidence Act.
That is your name.
We use it in counsel for first accused. Section 106.
Huwezi muona, huwezi.
Based on
Section 106B
on electronic evidence.
on electronic evidence.
You get your time.
And I'm not ready on objection because it's kind of part of it.
You get your time, get it.
Also, we have a next
Please,
evidence.
I want to confuse the direction for us.
Yes, sir. We have next a series of photographs marked as RR1 to RR37.
1, 2, R.
37. Your Honor, those photographs depict vehicles belonging to ACC, National Police Service, that were vandalized at the residence of the accused person. Yesterday, when the officers were executing the lawful mandate.
Executing.
Their lawful mandate. That is, doing a search pursuant to miscellaneous application E716 of 2025.
Come again. Miscellaneous application number
E716
E716.
of 2025. That is stapled in paragraph number 4. So now, photographs RR3 to RR10. RR3 to RR10. They depict the motor vehicle KCH 046T.
Come again. 0.
46T. After it had been balanced. There are photographs R11 and 12 depict KCD 628X after the violence. Photograph R11 KBU 7.41. And photographs for RR14 to RR26 depict the motor vehicle KCF 541 paragraph 7 and paragraph 8, the officer depots,
Sorry?
paragraph 7 and paragraph 8, Mr. Ronald depots that after vandalizing these vehicles, important documents were taken. Now, you take judicial notice of the position of the first case. The witnesses in this case, Your Honor, upon disclosure, are his subordinates, people employed under his government. Now, what is the test of interfering with witnesses? It is not beyond reasonable doubt. The test is just a reasonable prospect that is maintained with the witnesses.
The test is?
A reasonable prospect that the accused person will tamper with the witnesses and the evidence.
Perhaps, and I'm aware of the directions you have given about the temper. Perhaps we need your guidance whether counsel can go outside the content of his affidavit and claim to bring averments that are not contained in the affidavit, because that will prejudice us in terms of our response. Because there is no averment in the affidavit to that effect that the proposed witnesses are subordinates of the government.
I'll give a guidance again. Whatever you pick along the way from both submissions, kindly bundle them together. Once you rise, I expect that you address all the issues in one sweep.
I want to get
But let me record you first. Mr. Kula, give me some time. Just to record his objection. Everyone, I need to
I will repeat you on that.
How long more? I thought we were going to take 3 minutes. Now we are going to, we sit here the whole day. Just off the cuff. How long more?
I'll take it. Tell me. Yes, summarize it.
10 minutes. Continue, Mr. Cook.
Yes, sir. I will repeat
So
that.
your 10 minutes.
We are submitting that once disclosure is done, the witnesses will be calling officers from the first case time. Those are his subordinates. I'll get the second claim. It's a very good offense.
Sorry?
I got the second compelling reason. When appraisal of the child, the amounts will appear cash.
As we last year,
minimum 1
meaning
million. I should believe Your Honor will win this case, and will draw your attention to section 62, 1. Over 7. 62, 1 over 7. In the event we succeed, that provision is very punitive.
in the event,
We succeed,
we is
the
the
DPP
DPP
prosecutes this case, we get conviction.
is successful.
Yes. We will be moving to section 62, subsection 1. And on that, the severity of corruption cases. Will it be a recipe for someone to interfere? We submit to the positive, Your Honor. Lastly, public safety. I've alluded, Your Honor, to what transpired yesterday. And I've alluded that investigations with regard to other cases are ongoing. Our submissions is that if we release the accused person today, what transpired yesterday will happen. And we are apprehensive that in the interest of justice, in order to protect the integrity of the criminal justice processes, the application is allowed, and at least for the court to have an independent opinion, a plea bail report be available. A plea bail report be available before this court can decide on this issue. Thank you.
Sorry, Your Honor. Just to underline that our prayer is that the first accused be denied bail. That probably is the last sentence. Thank
Mr. Jero, how many of you would like to lead this with? Because I listed, how many? Listed 11.
Yes, and one, not all of us,
So how many? Just to manage our expectations.
About five for practically five. We go for drama. You know, drama, we just want to take for issues. Because the issues are straightforward, you know. But let me start by introducing Senior Counsel John Greenwan.
Huyo ndiye anakuzuia kamera
Our
mrefu.
guy.
Rudisha nyuma.
So we have an introduction. Then how we do it. How we do this also, yeah? So that is
Ateremsha chini. Ambia
You're
ateremsha
not-
chini.
let me be the first one to draft this.
Uko sawa? Uko sawa.
me on the outset state that the prosecution is causing the necessary drama in an otherwise straightforward manner. And our focus at this point will be the rights of the accused person, who remains innocent unless and until he is proven guilty.
Huyo na ateremsha kitu yake chini.
So no amount of reasoning.
Uko sawa.
Yes.
Ateremsha chini. Amezuia. Chini.
So no possible grounds can be advanced that can be directed at taking away the accused person's rights. That should be the starting point. And some cases, Your Honor, as a counsel was now practiced for 33 years, I get concerned
For how long is that?
33 years.
That is not for intimidation.
It is fun. It is fun. When we
But
propose-
I'm sure Dr. Hamira is smiling at you.
Actually, it's a sign.
Very sad.
Your Honor, when prosecution proposed to teach this court the law, citing authority, citing sections, trying to tell you how to deny it. Before I stand here and pass about, I'm certain they do not believe in what they're saying.
Sorry, Your Honor. I know the court warned us of decorum, but we plead, I am just 12 years in practice. We plead that senior Macharia doesn't get personal. We are just here for our cases. Anything that we do is not personal. So we plead with him to have mercy on us and just stick to his case without attacking us. Thank you.
Let us have mercy on the first case.
Mr. General, to record his objection. There is a special reason, Mr. Njebo, I did what I did to your side, so that we remain focused. So remain in that trajectory.
Absolutely. My plea is that we have mercy on the accused person. Let's not talk about mercy on the prosecution or media. We are outside. It is him who's left in custody. Now, Your Honor, I'll say this with tremendous respect. What we have here is warfare, which I urge you, Your Honor, to take judicial notice of, because we live in this country. We are interacting with social media. We know what is happening in our country today. And none of us can afford to shut our eyes from that. Independent agencies are being captured and being used to weaponize matters of justice. That's what lawfare is all about. Where you use legal processes to attain an ulterior objective, which is to harass political opponents. It is sad, extremely sad. make a confession to you. I was last in a criminal court defending somebody 20 years ago. But this matter made me extremely agitated, and I said, I will come back to the criminal court to defend someone. Not because of his status, because we can't allow a country to degenerate to a situation where the criminal justice system now is used to harass opponents. That's wrong. And we shouldn't allow it. Your Honor, to intimidate, I am one of the few lawyers who have had the advantage of having been part of independent agencies and also been private practice. One of the few. And I know how things operate in those agencies. I was the first year of independent police oversight authority, and we had a lot of run-ins with the executive. Constant interference, attempts to direct us on how to do our work, including by the current president when he was deputy president. And this is factual. It's in public domain, it is known.
Mr. Jero,
I'll give the context. I'll give the context. Yes, I'll give the context.
Focus here, Mr. Jero, a minute.
I'll give the context.
A minute, Mr. Jero. The focus here is the accused, the law, the constitution. You understand our parameters, if you like. There are some parameters I am unable to swim in. I may not be very able to swim in. But I can swim in the constitution, I can swim in the law, I can swim. That's why I can swim in the submissions around those lines.
The reason why I'm telling you that, Your Honor, so that I can go straight to the context,
Yes.
is that independent agencies will come here and pretend more often than not that they're doing their work independently. I'm telling you, as someone who has been in those agencies, that unless as an individual you have the wherewithal to resist and do your work correctly, very few manage to do that. That is the context. I'm not here to talk about where I was. And
Sorry, Your Honor.
It's just to indicate.
Sorry, Your Honor, we are forced to object once more on the question. The factual matrix that the very learned senior is giving us are things that, with respect, he cannot tell us from the past. We would believe him, and I know he's a very truthful man, but for us to believe what he's telling you to believe, let him give us an affidavit of those facts so that we're able to respond to those facts. Without that, we humbly plead again. We humbly plead that he gets back to the case and not tell us the other things that are factual and there's no affidavit. We plead with him. We understand that he's previously the commissioner. We understand. But let him get back to our case. Thank you.
To respond to that, look at the affidavit.
A minute, Mr. Jero. I complete the question.
You're gonna,
Mr. Jero, your brief response, you are responding?
yes. If you look even at the affidavit, they've made general averments. To start with, problem number one, they serve us in an affidavit this morning. What time did they expect us to respond to that affidavit? You know what is the trick? That it is designed in a manner that will us to make an application for adjournment so that we can file an affidavit. And in the meantime, person produce languishing in the custody. You know those streets. Then the affidavit itself is marked with general affirmation. This is factual. They are talking about respondents agents, they are not naming which agents.
So just to be clear, you responding to the objection or you continued with your submission?
I'm responding to
That I'm
something
clear.
that he cannot say that I'm making general affirmation, yet in his own affidavit, he has made very general affirmation that are in support of denial of bail. Then he expects that I shouldn't be able to respond to that. At least from the back, in the very least, that should be expected. He can't have a state and Egypt. In fact, we should be given more latitude because the subject of these proceedings is the accused person. The rest of us are sleeping here, and then we walk away. But it's the subject. That is the person we should focus on.
Zero, give me a chance to give direction. Somebody wish to guide again that we focus on law governing content bail. That is the issue of the table. Continue, Mr. Njero.
Much obliged, Your Honor. Now, Your Honor, the accused person is somebody who has served this country for a long time, not just as a governor. Knowledge of who he is in the public domain, including the very sensitive security agencies. And he also understands the law by his own right. He understands his obligations to the public security. Besides being a governor, elected governor of a county. What was so difficult was just someone to court, telling me to appear in court in such and such a thing. Why all the drama? Arresting the man and putting him in custody for this kind of charge. Why? It can only be for the sole purpose of punishing him. It can't be anything else. And it is that desire to continue punishing you that is driving the application for you to be denied bail. You cannot allow yourself to be in realizing that objective. You can't. I have consistently seen the last line of defense of this country. The only one remaining, Your Honor, is the judiciary. And if judges and judiciary judicial officers allow rights of accused persons to be taken away. We have no country. None whatsoever. And let's not think that when you allow that trajectory, that everyone will be safe, including the prosecution itself. No one, I can tell you, Your Honor. We need to learn from history. So regardless of what happens here with these protracted submissions and responses and counter-submissions, Your Honor, I beg, do not fall under the trap of saying that you're going to write a ruling another day to be meted in this custody. Don't allow this man to remain in custody. He's already been punished enough by being put in custody, even for that one night, when he could have been summoned to appear in court, and he never appeared. One of my colleagues here will speak about the facts, then the chaser, but I can tell you, Your Honor, this alleged misfunction that is being talked about, the accused was in Nairobi. Whatever is alleged to have happened was in Kitale. How do you start connecting him to something that is happening hundreds of miles away when he was in the office of EACC? How? So I'll allow my colleagues to say something, but I'll end by saying this. The reality of our times is that between now and 2027, these are the kind of things you're going to see continuously. Lawfare, use of the criminal justice system to intimidate and harass opponents. Your Honor, I once again plead with you, do not fall into that trap. I'm confident you will not do it.
Thank you. Thank you, Your Honor. Briefly, just give the last aspect. Your Honor, just to associate myself with the submissions made by Malani Senior, and to draw your attention to the content of the charge sheet, from where you will be able to drive the mischief. And the accused person is carried.
Slower. Pause after every sentence. The accused person.
It's not surprising that the accused person is charged before you with another person, Wafula Masungo, who is not before you. This is not by coincidence. It is not that Wafula's whereabouts is not known. It's because, Your Honor, the state was in a hurry to perpetrate this mischief. In normal circumstances, Your Honor, such proceedings would not have commenced. When we sought for explanation, Your Honor, Malani Senior indicated that he was seeking summons. It's the same mischief, Your Honor. When you sought for clarification from the prosecution,
Slower.
Their position, Your Honor, was that you seek summons. And the nature of the summons was not indicated to you. That is to say, Your Honor, therefore the application for you to deny bail must be read in light of that mischief. That other than pursuing public interests as dictated by Section 4 and 5 of the ODPP Act, the ODPP is equally pursuing other ulterior motives that are politically actuated.
And our apologies. Also, the elections, to directly the focus on the judgeship of the business. It comes to us anyway. Also, the elections.
Minute and recording is start.
The direction.
Minute, I'll give you directions.
The director will focus on the judgeship and the issues related to bail. The colleague is submitting on a fact. Unless he has evidence as to what he wants to speak about, we will ask him to take the stand on the other side and we will read it to him. So let him speak on bail. The rest of this person. We just not infuse any motive to anybody unless they are willing to take the law and willing to participate.
The response, Mr. Njiru.
Your Honor, my response is contained in the affidavit filed by the ODPP. But it's not surprising, Your Honor, that the affidavit contains mere speculations. It has no tangible evidence that proves to the contrary of what I earlier submitted. If I was to proceed in response to the substantive application,
Minute. Must give direction in the objection. I remind that once more, I think belong to the law on bond and bail. Avoid instances which may persuade me to request the fact having evidence from your end,
I am well
which
ready.
will render you in a very awkward position.
I am well ready.
But
Your Honor, the affidavit contains mere speculations. There is no affirmation in the affidavit.
minute, after every sentence, you have to
And there is no affirmation in the affidavit that is linked to the charge sheet before you. The affirmations in the affidavits have no nexus with the charges before you. these are matters that are happening in other spaces, which none of us, neither the prosecution, nor the defense, nor the court, are privy to. That is to say, Your Honor, that to deny the accused person bail on account of presupposed investigations would be tantamount or will amount to violating his constitutional rights. And most importantly, the right to presumption of innocence and the right to liberty. The argument here that the intended witnesses are subordinates to the governor, the accused person, again is not contained anywhere in the affidavit. And the same does not amount to a compelling reason. And so to say, Your Honor, the argument that vehicles were destroyed by his agents when there is clear lack of evidence linking the so-called agency with the accused person, again is speculative. Has no probative value of whatsoever nature. The same is not empirical, and there is no nexus between that affirmance with the affidavits and the accused person. And as such, that cannot be considered to be a compelling reason. More annoying, Your Honor, more annoying is that the office of the ODPP, which is fully funded with the taxpayers' money, had no courtesy of proving the ownership of these vehicles. You know, the producer of the so-called annexures, for instance, will not tell you who is the registered owner of KBU 734Y. Again, from the same annexure, you will not tell who is the registered owner of KCH 046T. It will not tell you who is the registered owner of KAE 7-8F. And you're being invited to deny bail on that ground. Registration of motor vehicles is a legal process. It is guided by the Registration of Motor Vehicles Act. And if you are courteous enough, respectful to the process and the proceedings, and holding the values of the Constitution of accountability and transparency, they would have consulted the NTSA. Permit me just to, as a pen off, and invite my learned friends to draw your attention to the charge sheet once again, that there is no charge that the government is facing that is linked to its office. There is no way in the charge sheet that says that the governor abused his office. There is no way in the charge sheet where there is a charge of conflict of interests. That is therefore to say In the absence of such kind of overcharge, in the absence of evidence, the argument and the averments by the prosecution is not to be believed. I was perplexed, Your Honor, in summary, when I heard my learned friend, Mr. JV, invite you to look at Article 50 in isolation of Article 25, in light again of Section 8 of the Magistrates Court Act. He invited you to hold that the only jurisdiction you have in that respect relates only to Section Article 25 A and B. Curiously enough, and in the attempt to persuade you, he delinks the presumption of innocence and a fair trial from Article 25. He tells you that the Your Honor, that the presumption of innocence.
I need to stop.
Or finish. So people can see the first. He tells you that the right to presumption of innocence and Article 50, as protected by Article 25, can be limited under Article 24. That's a fallacy. It's a fallacy, it's a misconception, it's committing injustice and defiling our Constitution. Family, Your Honor, what is compelling? If you look at the law, Black Laws Dictionary, it will give you as to what is deemed to be compelling. That thing must be a strong issue, it must be convincing, it must be legally justifiable. It must be, or it must have the effect of compromising the integrity of the proceedings. None such averments has been pleaded. No evidence produced. No law quoted. No case law referred to. And as such, Your Honor, the granting of bail to our client will not prejudice, will not compromise the integrity of the proceedings, will not affect the so-called pending investigations, and Your Honor, be minded of Article 24 and be minded of the test therein. When can a right be limited? A right can only be limited if it is just reasonably justifiable in a democratic and an open society. I invite Mr. Jerry to guide us on who next. Thank you.
We will take more than 10 minutes.
10 minutes. I also give you a case law.
So how long are you?
10 minutes.
10 minutes.
I
I'll manage the situation.
Always remember, the court has also business. So if we submit here the whole day, we understand the application, right?
We understand.
So we cannot submit the whole day and expect magic. We should be reasonable, and they say, for a wise man, one sentence is enough. You don't need to give 100 sentences in circumstances where you can give one sentence. I think that broad guidance serves us right?
Yes.
So we don't need to talk, all of us. In fact, I expected Mr. Njeri to ground this. There is no need of all of us.
We will be very brief.
We are guided.
So this is Mr. Chesa. Mr. Chesa, I'll give you 5 minutes.
Very well. Your Honor, I want to start by raising an issue with the manner of arrest. Which manner violated Article 25A of the Constitution and Section 8 of the Magistrates Court Act gives you authority to inquire into these violations. What this court gave the EACC was search warrants, not search warrants. Which they abused by literally breaking into the accused person's residence in Kitale and Nairobi, bundling him into a police vehicle and detaining him at the Integrity Center offices. We hold that the arrest was barbaric, unlawful, and an affront to the dignity of the accused person. Your Honor, to deny bail, the High Court in Johnson Mgunya and another. This is the Mombasa criminal case number 26 of 2008. The High Court said the prosecution must provide cogent, the term there is cogent evidence and not mere allegations. You have been told through the affidavit of Mr. Rono, he keeps referring to some ghost creatures called agents of the respondent. Agents of the respondent attacked EACC vehicles. Agents parents of the respondent shouted at integrity center. And that's a very serious threat. They have not drawn the matrix to link Governor Natembeya to the so-called agents. Was it Governor Natembeya's wife? Were they governor's children? Were they his staff? There is no such evidence placed before you. And those who amount to rumors, and this court must not listen to them. The accused person, Your Honor, is a decorated career civil servant. He is the governor, government of Transoya County. He is a deputy party leader, one of the most progressive parties. In all this, he is not a lonely man. At the time, the so-called ghost agents were shouting at the integrity center buildings. The governor had been locked up in the police cells. He had no access to his phones. He was only allowed one advocate, Mr. Simiyu. The rest of us were locked out. Jero was asked to get clearance for lead escape. Jero was asked for clearance for lead escape to access his client. At what stage did the governor plan with the so-called agents to do the unimaginable things that the state is supporting? Your Honor, in Nairobi miscellaneous criminal application number 351 of 2016, in Nairobi miscellaneous application number 351 of 2016, the court said that the seriousness of the offense per se is not a ground to deny bail. At the time of arrest, 2 more minutes, Your Honor. 2 more minutes, I'll be done, if this court allows. That just have 2 case laws, and we can do that 1 case law.
If we can stick to directions of the courts.
I understand you,
You've already done more than 10 minutes. I gave you 5.
Just
I
one more.
lost my eye to say you're finishing on the 6th minute.
Okay, just 1 more. In that case, you recorded that the seriousness of the offense.
I repeat, 1 word is enough.
Lastly,
I don't know why we get this temptation, that the more I speak, is the more I persuade. Sometimes it's counterproductive. Can I bring it to your attention?
yes. One,
Sometimes it is counterproductive.
this last one, R versus Richard David Alden. R versus Richard David Alden. David Alden. The High Court at Nairobi. Criminal case number 48 of 2016.
Second case. Just list them. I will look at them.
Very well. I think that was the last case, and that the person must demonstrate actual witness interference, not mere allegations.
Straight up.
Witness interference. Employees of the county government are retained by county service board, and not the governor. Therefore, there is no relationship between the governor and the employees of the county government, save for CECs who are merely policy makers. That is all.
Your Honor, with your permission, Mr. Simi was the accused person in the ACC. He only say one word. He follow your guidance. Your Honor, Mr. Simi.
Your Honor, take 2 minutes.
I'm addressing you.
Proceed, Mr. Simi.
Thank you, Your Honor.
Your Honor, number one, I just want to write on what Mr. Chester has said. The accused person did not have capacity to
This
direct,
person?
did not have capacity to direct third parties to commit acts of vandalism. Your Honor, I have an inventory.
Slower. You need your 2 minutes. Let's
Yes.
take it slow.
Your Honor, I'm worried about my 2 minutes. Your Honor, I do have an inventory. Yes, Your Honor, which will demonstrate to you that indeed, as at 6:30 a.m. yesterday, the accused person had lost his 2 phones. And of course, he was in custody. So he could not speak to third parties. So, Your Honor, there are vermins in the affidavit by Mr. Robert Rono is certainly not accurate. Number 2, Your Honor, the place where they went to conduct searches. Your Honor, I want to refer you to the affidavit of Mr. Rono at paragraph 3, where Mr. Rono says that among other places, they went to accuse persons Itale Milimani residents. That is repeated at paragraph 4 and paragraph 5 and paragraph 6 of the affidavit. Now, Your Honor, juxtapose that to the order. The order that they received to search the accused's premises had the following residences. One is Rongai residence in Nairobi. 2 is a residence in a place called Kipomet.
Come again.
First is
No,
a
the second.
Second is a place called Kipomet. Kipomet. Third is Nairobi residence in Kileleshwa. Okay. So that, Your Honor, when you turn to the affidavit, and of course they are using paragraph 6 particularly to seek to deny the accused person bail, they are saying that the motor vehicle searching his Italian. Your Honor, looking at the order, which Your Honor you can have a look at, the Italian evidence is not captured. It's not there. And therefore, Your Honor, we are appealing to you that the evidence that have been annexed to the affidavit is illegally obtained. And we are not very sure that the pictures that are said to be connected to the accused persons are genuine. And Your Honor, to cut that, I would want to refer you to the Evidence Act, Section 106, Capital B.
I refer you to Sopec.
I-
You read it recently.
I leave.
Honest to records.
Thank you.
Your Honor, I'll try 3 minutes at max, and you stop your time.
Be sure it is 3 minutes.
Stop there now.
Yeah.
The first point, Your Honor, is just to raise a point.
Now, I expect you start with what you wanted to raise.
Yes, that's what I'm addressing. Your Honor, Section 106, Appendix B of the Evidence Act is very clear in the manner in which electronic evidence is used. There is no certificate of electronic evidence annexing those pictorials. By dint of that section alone, there is no evidence in support of the bare allegations in the affidavit. There is no basis to even advance now any compelling reason.
Slow. Let me remind you. The applications contained in the
And in the absence of the electronic certificate, the annexures are inadmissible, and the court should expand them. In their absence, there is no evidence brought to court to support the opposition today. Finally, Your Honor, you are told that this court cannot interpret the Constitution. Section 3 of the Jurisdictional Act lists the sources of law in Kenya that this court is called upon to apply. This court can apply the Constitution, including the Bill of Rights. When we say the court to apply Article 49, to apply Article 50, we are asking the court to apply it in the ordinary course of the court's duty. We are not asking for interpretation. Last point. Everything remaining constant, the right to bail is constitutional. And the purpose of giving terms is to compel attendance. The subject of the proceedings is now a warden of the court, not a warden of the state. Bail and bond for pre-hearing detention should never be used as a basis to punish an accused person who is still presumed to be innocent. And I urge Your Honor to so consider this accused person as its warden that will attend to court as and when this court requires it.
Mr. Jerry, your last soldier. Is it your last or
Listen and then I talk about Amino.
Dr. Amino?
Thank you, Your Honor. I'll take only 2 minutes.
Professor, you
Your Honor, I'm very pleased to appear before you to demonstrate that what I did recently in my second PhD in criminal justice should be put in a maiden opening, and you are the first that I'm hearing before, so I'm very privileged. Secondly, I'd like also to thank my former teacher, Smil. I think he taught me very well, and that's why I've been proceeding on. Now, the point that I want to make is just one or two. I would like this court to look at the whole history of the government and intergovernment officers calling themselves ESCC and their mandate. I would like to apply what we call strict scrutiny. Strict scrutiny test. Law, whereby the government raises its own legitimate expectation to validate it is incompetency. Incompetency is aligned to rights protected by the Constitution.
Come again?
Incompetency is aligned to rights which are fundamental and protected by the Constitution. If that was the case, then that law must be narrowly, and I mean narrowly tailored to serve a compelling interest. What is a compelling interest? I'm not going into that issue because my senior counsels before me have already spoken about that. How do we look into the classification of what the state has alleged? Classification. Classification, looking at the time of the search, the time of arrest, the time taken to drive, the accused, the miles involved in that journey, the manner in which the accused was transported, where the accused slept, presumably in this case a cold floor, and how the accused was arraigned in court. Lastly, Your Honor, I may not understand, and please let the court make me understand, whether the arresting officer is the investigating officer and the judge, and is an evidence provider, provision of evidence through affidavit, which even if mandated by statute, and even if that statute contradicts the Constitution, in which case I believe it does, following the circumstances in court, then there is high potency of illiteracy in the judicial, in the government executive system. I rest my case. Thank you.
Professor, you sure you want that to go to record?
I think it should, because I can substantiate
Literacy in respect to
Your Honor, what I mean by literacy is not literally academic schooling, but experience. And if we were to do what we call discoveries in law, the kind of affidavit you have seen here raises issues that can only be raised on discovery.
you're admitted yourself.
Thank you.
Thank you. Daktari, how long? I'm not even
I
sure
will be
whether I will fix time for you.
Your Honor, I will be extremely brief,
Very well.
except I'm asking for one indulgence.
Yes.
I have my own friends in Ethiopia. I always appear with him in the cases. He has got only one word that he wants to tell you. Only one word.
Very well.
One word will take maybe 1 minute or less.
Very well. Continue.
First, please look at the charge sheet. Point 1, the persons named there are 2. The particulars refer to 1. It is impossible to tell which one will be, except for the use of the word government. So we don't know whether the fuller is for government or the government for government. The second point related to that is particulars in the charge sheet under the law. And I take it to be something that the court knows how to do that, right, and understand. Those particulars which are suggesting that he has committed an offense of corruption, of conflict of interest. The particulars of conflict of interest are not been indicated. So without the indication that what you call the seriousness of compelling evidence is not there. If you look, sorry, we have that code, that was speaking this. If you look at count 2, the same problem of lack of particulars. So that there is no evidence that demonstrates the nexus between Mr. Natembeya and the brother. And the third count relates to the manual we don't talk about. Last, and this is about the allegation of planning cars of the government. Something I was told when I was being taught to the grandparents when I was much younger. We were told monkey see, monkey do. When the government itself lets court orders, citizens have no reason to monkey see, monkey do. When government routinely violates court orders, it is impossible for citizens to trust it. So nobody will trust that they are doing anything unfair. So the citizens are taking after the act of the government. And very last, I do recall off the top of my head, the governor of Istanbul, who was charged with the reply of support. The court ordered that he should not go to the county government. So this issue of interference with subordinates, if there are any, but my colleague, I just every that's not still. The court has authority and discretion to give conditions that will ensure that the proceedings of this court are currently being taken.
Thank you very much. Your Honor, I was very, very, the first point I would like to make to you, respectfully, Your Honor, is that several counsels or advocates have spoken, they have made submissions. I would respectfully argue that before you write a ruling, identical ruling, it is very necessary to guide this nation. You release the governor and you tell the audience that a recent ruling will be delivered. Your Honor, this has always been done by the Court of Appeal, by the High Court. This has always been done by the Court of Appeal.
This one?
Giving reasons later
Yes.
has always been done by the Court of Appeal, the High Court, and recently even by the Supreme So I ask you very respectfully that before you rise this morning, you make an order that the governor is released forcefully and you deliver the body later. I also urge you very, very respectfully, Your Honor, that if you are free for it, the governor will go nowhere. We all know it. He lives in this country. He has rendered sterling services to the nation, and there's no way he can leave Kenya for another country. Give him a free fall. And you will also be educating certain people and certain people that the criminal law of the country must not be abused at all.
Slower, Daktari, slower.
Your Honor, I'm saying to you respectfully that you make an order before you rise.
Sorry, that I scored. And it's okay.
That the governor is released on a free bond and you will give your reasons much later. Your Honor, permit me to continue.
Go on, continue.
Your Honor, I'm a child born in the colonial days.
You're a child of
Born in the colonial days.
colonial days.
I'm a child who received education in colonial institutions. I'm a child who read colonial literature of sociology, anthropology, philosophy, when you had terms like the African mind, how the African thinks, and so on, from the colonial days. There's one thing I can make you very clear. The criminal law of Kenya has always been abused. It has always been abused by those in power. It was abused during the colonial days. It was abused during the Natembeya state. It was abused considerably during more state. The only president that can put in a word in his favor is my but the criminal law was not abused during that is
I think the statement is home, Daktari. The statement is home.
Oh, thank you very much, Your Honor. Now, Your Honor, permit me to go a little bit further. It is now being abused by the executive, by agents of the state. They have now taken over the criminal law of the country. They are abusing it. The rule of law which we thought was improving is now in ICU. And Your Honor, I'm urging you very respectfully that you can only get out of this quagmire with boldness from the judiciary. Our judges have to be bold. Our magistrates have to be bold and state very clearly that the country will not be governed the way it is being governed at the moment. Your Honor, we live in this country. Every day I'm reading the Sun, I'm reading the Nation, I'm reading the Star, and I go even further to read any other newspapers outside this country. Clearly, Your Honor, what is emerging at the moment, that unless we arrest the situation, nobody will have politics in the country. The country could easily be classified as a banana republic. I filed a case recently, Your Honor, in court, the usual process, that we should refer certain matters now to the ICC.
Oh, Your Honor.
That we should refer certain matters of disappearances to the ICC. Let the International Criminal Court come in and see what it can do, that it can come.
Daktari, if we can deal with Mr. Natembeya first.
Yes. Your Honor, what is the judge? Can somebody you are given here, one can even pass in class. The first comes. The governor is supposed to have corruptly received the sum of saying 1,127,900,000 shillings. You're not being told that they took away billions of shillings. 1,127,900,000 shillings. Anybody with a critical mind like of John Camino can see that this is dishonest. It's nonsense. That you're bringing a governor of the state to the country because of that amount of money. That's on the first page. On the second page, 2,124,668. Hey, what is that? A full governor. 2,124,668. Sadly, Your Honor, the amount involved is 2,680,461. This is of Emmanuel of Musumo. Your Honor, the criminal law is being abused. During the days of so let me make one point clear. A constitution has been meaningful, it must develop something called convention. A constitution is meaningful, it must develop in some cases something called convention. You would expect that a charge against a governor of the country, the director of public prosecution, would lead the entire file to satisfy himself that indeed a case has been made out before placing such a case before a criminal court. Your Honor, when did the DPPs read the file to satisfy himself that a case has been made out against Mr. There? Having regard to what was being told, yesterday morning. When did the DPP read the entire file? And this is what I may say in favor of Charles and Johnson. He would read the entire file to satisfy himself that indeed a case has been made out against the government. A governor is no small man. A governor is not a messenger. A governor is a person who is ruling and governing millions of people. It is therefore not surprising that the people in his own area were mad to hear that their governor is being brought into the country, taken by the police. It's quite clear the file was not read at all. Your Honor, may I say, draw your attention to the fact that I shall, if I'm given the opportunity, I shall be conversing in some other quarters that the courts have no jurisdiction to contain the count that they have to that people. There's no jurisdiction at all. And I would refer you to Article 181 and Article 182 in the Constitution. If you read Articles 181 and 182, Your Honor, there is no provision that provides that a charge can be prepared against a governor. The way to deal with a governor is to use the impeachment proceedings that have been provided for in the Constitution. A governor cannot be arrested and charged the way things have been done. The director of prosecution himself, Your Honor, the DPP has no jurisdiction to make or to prepare charges against the government. So there's lack of jurisdiction. I'm making this point to strengthen my submission, Your Honor, that there's no case against the government. Your Honor, one final question, or one final submission in the next year. Please don't misunderstand me at all. I've often thought that in a country like Kenya, strictly speaking, you do not have to be bright. You do not have to be bright in the law at all. What is required of a lawyer, what is required of a magistrate or a judicial officer is to be strong and to be courageous. The mind in your face that rise to the occasion and show those who are in power, who are in executive, that your powers can be challenged, that your powers can be reduced by the courts. And it is the courts that are in control of the country and nobody else at all. If we lose the control of the courts of the country, if we lose the power that the courts have, Kenya can easily and very shortly be classified as a banana republic. No wonder that the president of Tanzania said the word that he said about our country. The country has gone up. And we need young people like yourself, who have got power, to see whether we can bring up and maintain the concept of rule of law in the country, the independence of the judiciary, and to make sure that we can use the word and borrow the word of our president, that let the executive keep its own day, not to get into other days. And currently, it is not doing so. Thank you. Your Honor. After Your Honor. Yeah. Your program may say that when the matter I handled in some other quarters and so on.
Mahatma.
Yes, there is a book here I will be referring to impeachment in the Nigerian presidential system. That's where we have a lot of impeachments of governors and so on. And I will be borrowing words from this book. I'm just putting my learned friends from the prosecution notice that they order for this book.
What is the title?
Order.
Your Honor, I'm taking the title. It's impeachment in the Nigerian president. I assure the very learned senior that you have come.
Yeah. There's I don't know if it's on the impeachment of governors, Your Honor. And in Nigeria, you will see when members of the executive swearing that they would rather die than have such a governor in power. Yes, some people, I'm sure, are swearing that they would rather die than see Governor Natembeya in power.
Very well.
Thank you.
Mr. Njelu, I think we are done.
Yes, we are done, so it's
Yes.
Our father, the father, the profession, he has said it all. The governor, freehold, at the very worst, some affordable cash flow. Let him not stay here an hour longer, so that we don't play in the hands of his tormentors. There have been no conditions. This man has been elected by his people. He has committed no wrong until the case is proven, if at all. There was not even any affection in that effect. So let's not talk about conditions. In fact, that date, one of these expanded. Let him get his freehold or cash bill, let him leave. Even a street boy here will know who is talking about there. There's nowhere where he will go. We believe. Your Honor, we do the right thing. We have no doubt at all. I, for one, have no doubt. I know you are a good judicial officer. You believe in the rule of law. You understand the law. And even as we are doing all these things, you've appreciated it. I have no doubt that today the judgment will be will come. No conditions have been sought and shouldn't even be there. Let man go and serve. He'll have his day in court.
Thank you.
Sorry, Your Honor, do we have a right to respond?
Of course, there are any objections.
I'll just go alone. Most
You have
kindly.
not specified.
Yes. Your Honor, start with the jurisdictional issue that has been raised by counsel, especially the very learned Dr. Amino, as to whether or not this court properly has jurisdiction to entertain these charges. And whether or not the Director of Public Prosecutions had power to institute these charges. Yes. And that is related to reference to Articles 181 and 182 of the Constitution relating to vacancy in the office of a county governor in Kenya. I believe, I haven't made reference, but I believe that's the position. In brief responses, this court's jurisdiction to entertain anti-corruption matters is provided for under Section 4 of the Anti-Corruption and Economic Crimes Act. So that's a simple answer. Section 4 of the ASEC. So this court has jurisdiction. The Director of Public Prosecutions is vested with power to institute criminal proceedings against anyone before any court other than a court martial, Article 157, 6A of the Constitution. Allow me to make two corrections. My very good friend, Mr. Degwa, tells the court that there is no nexus between the affidavit and the charges. And if your record confirms what I also heard, that there's no such charge as conflict of interest, which is count number 1. I don't know whether counsel read the charge sheet. Count number 1 is conflict of interest. And not just that, count number 2. How could he have gotten that wrong? Conflict of interest. And it does not only mislead you on that. He says that the prosecution, on behalf of the prosecution, no law has been pleaded, no evidence has been produced, no case law has been referred to. I refer to Tom Chomley, case law in Kenya. I quoted Article 49(1)H. I quoted Section 123A. These are laws in Kenya. The second correction, Your Honor, my learned senior, Mr. Masharia, if I don't get that wrong, tells the court that the areas, the subject of the warrants issued on 18th of June were limited to 3, Kibomet and another one. It's on the record, Your Honor.
Sharia also.
Oh, Mr. Sibiu, I apologize. That's why I was not sure who's in. Your Honor, although they have not given you a copy of that warrant, it says, and any other warrant. Let me just read that so that I get it correct, so that I don't mislead the court. The warrants have been referred to just below the areas listed. There is and any other office, business, and residential premises wherever they may be situated within the Republic, unless we are reading different ones. So that even the search in Trans Nzoia was by law, was sanctioned by law. But then there's the related question as to whether the warrants issued could also be the basis of an arrest. That is the question asked by my learned friend and teacher, Mr. Chesa. Your Honor, this is a cognizable offense. Mr. Smith taught me this way back in 2011. For cognizable offenses, you don't need a warrant. So the arrest was proper by law. So the arrest was proper. The searches were proper. The defense has attempted to repudiate the charge sheet. Although they have gone around the corners, they're not coming strongly about it. But they seem to be questioning the propriety of the charge sheet, or rather the charges. There was no attempt to invite this court under section 89.5 of the Criminal Procedure Code to reject the charges. Plea was taken. As it is, the charges are proper, including the particulars. And in compliance against with section 214 of the CPC. But there's a smaller issue about the amounts. This is related to the charge sheet as well. That a whole governor should not have been brought before you for amounts about 1 million or 2 million. I agree with Mr. Otieno that this court may not interpret but can apply. In the application of the constitutional provisions, Article 27, Subarticle 4 obligates this court to ensure and promote an equal application of the law to everyone. Equal application of the law. Article 27, Subarticle 4 of the Constitution. Before this court, Your Honor, I've never had the privilege of appearing before you. And I'm sure my colleagues who have here have brought people with cases of soliciting a bribe. Some of them up to 3,000 or 5,000. They are Kenyans as well. So that the amount, the basis of the charge cannot be the basis to question whether or not the charges are proper or whether or not compelling reasons exist. Your Honor, I can confirm to this court that's a factual issue, but I can confirm to the court that the DPP, in fact, ascertained and satisfied himself that there were charges properly on the basis of which he could institute these proceedings before you. Your Honor, in respect of Article 181 and 182 of the Constitution, we are not attempting to impeach the governor. The DPP has no such powers, legally or factually. But Your Honor, more importantly, whether or not denial of bail would amount to removal of a governor has been answered by the Supreme Court of the land in the case of Ferdinand Waititu versus Republic.
You know, he's raising new facts that were not part of address to the court.
That's a question of law, Senior.
It never came up, Your Honor. We perhaps need a very clear ruling on that particular objection, because that never arose in our submissions.
Dr. Aminu raised Article 181 and 182 and said that removal can only be by other parties, not the DPP of this court. That's what I'm answering. And again, because Mr. Ndegwa did not even know that conflict of interest was count one, he may have missed this as well. I withdraw.
If you have withdrawn, I wanted to clarify that I scored with Dr. Aminu saying something else.
Yes. It's going to mislead. Unfortunately, it's going to mislead the court.
Now that he has withdrawn, there is no need to clarify that point.
So, Your Honor, I further
I
withdraw.
scored him differently,
Yes.
so now that you withdraw,
Yes. most of like, I've also withdrawn the arguments on 181 to I call it different. So I've withdrawn. Your Honor, back to the question of bond as I conclude. Page 19 of the Judiciary Bail and Bond Guidelines, at the very bottom in the footnotes, refers to a case of, Republic versus John Kahindi and 2 others, reported in the Kenya Law Report in 2010. Republic versus John Kahindi and 2 others, 2010 EKLR. It is at the footnotes of page 19 of the Judiciary Bail and Bond Guidelines. The import of that case, Your Honor, is that the prosecution does not need to avail an affidavit in opposition of bail. Anyone can confirm because the guidelines are available online.
The prosecution
does not need to avail an affidavit in support of an application for denial of bail. While other courts insist on it, not all courts insist on it. That's the import of that decision. It's cited at page 19 in the footnotes. The importance of that argument that you make is that even without an affidavit, compelling reasons can exist. And so that the argument by Mr. Otieno that if certain documents were removed or expanded, then there's no basis. If we can come without an affidavit, there's still basis. There's also the argument as regards saying that we have not proved, sorry, Your Honor.
you are now on your 12th minute.
2 minutes and I'm done, Your Honor. I underestimated my abilities. I'm sorry.
You can't admit that. No, your pace, not abilities. I'm not doubting your abilities. You underestimated your pace.
Yes, yes.
Minute.
Thank you. Your Honor, I was referring to, please, Your Honor, just help me with your record. What did I say last? Kindly.
Last you were attacking the challenge by Mr. Otieno.
All right, yes, thank you very much. So Mr. Otieno was of the effect that if there is no certificate under 160,
that was concluded.
then I can move to the next point. You know, the other issue as regards bail, as I conclude, is that there is an admission from the defense, at least evidenced by Mr. Echesa and Dr. Haminwa. In Mr. Echesa's words, the first accused is a governor of a county. He is a deputy party leader, and he is not a lonely man. Verbatim, if I got it right. In the words of Dr. Haminwa,
I don't know whether Your Honor misquoted in my presence, actually in terms of understanding. I thought it was still points of law.
you were not sure what you are objecting on. Is it points of law or what you say?
As in, you have quoted my statement here in my presence.
Yes.
You clearly misunderstood it, and you want to go to the next person without clarifying the quote.
Sorry, Your Honor, I have not interpreted what Mr. Echesa said. I have quoted it as I captured it. So the court can confirm that he said that the first accused is the governor of a county, is a deputy party leader, and is not a lonely man. I am quoting you verbatim. I may be wrong in my interpretation, but in hearing you, I can't be wrong.
Points of fact. Points of law.
Your Honor, I'm coming to the point of law. I'm still quoting him. You cannot be the point of law. I am coming to the point of law. Yes, Your Honor, I'm still quoting so that I come to the point of law. Dr. Haminwa, on the other hand, says that the people in the first accused area were mad yesterday as a result of his arrest. Those are two admissions as to and thirdly, I am reminded that my very good friend, senior Dr. Haron Ndubi, mentioned that monkey see, monkey do, that the people have seen and are doing. The point of law we are making is that there is a likelihood of interference with witnesses. And that the influence of the first accused is admitted by his counsel on his behalf. And that it is not far-fetched that he would interfere with witnesses and investigations. Your Honor, clause 4.9 subclause E of the Judiciary Bail and Bond Policy Guidelines talks about likelihood.
Mr. Witt,
Yes, Your Honor.
you have said you need 30 minutes.
I am done. That is my last point. 4.9 subclause E of the Judiciary Bail and Bond Policy Guidelines talks about likelihood. It doesn't say certainty as proposed by Mr. Nego. If there is a likelihood because of that influence, there is a compelling reason you must deny bail. And standard of proof is on a balance of probabilities. I thank you for being patient with me. I am such a mouth, and we urge you that we have established compelling reasons to deny the first accused bail. Thank you, Mr. Your Honor.
Your Honor, permission to add one of the code section on the Honorable Jeremiah Kioni, Associate Counsel, who wished to place him on record.
It's now almost 1. Taking it so far. So I will need a break to do a ruling on the matter. I possibly need almost 1. We take a lunch break. Take a lunch break. Though the issues are going into millions, I will try the best to do it in 1 hour. And Dr. Haminwa encouraged me to deliver decision, give reasons later. Unfortunately, we have not been facilitated that way by our procedures. For the Court of Appeal, for the Supreme Court, they are facilitated properly by dint of their own procedures. Well, for the subordinate courts, that actually can give ground to suspect of my abilities and competence, which I do not wish. So we take a break. We resume at exactly 2 for the ruling. Much obliged.